hear them. Getting closer. All right. Good morning, everyone. I'm Judge DeLuca. Welcome to Broward County First Appearance Court. State, you ready to proceed?
Yes, Your Honor. Eric Linder on behalf of the state.
And the lawyer from the Public Defender's Office here in the courtroom, please state your appearance.
Good morning, Your Honor. Brian Reedy from the Public Defender's Office.
And the Assistant Public Defender at the main jail.
Hector Romero with the Public Defender's Office, Judge.
Good morning, Mr. Romero.
Good morning, sir.
Let me remind everybody, this is a limited proceeding. The nature of these proceedings is not to determine guilt or innocence, but only to determine whether there is sufficient probable cause alleged, and if so, what the custodial status will be pending further proceedings in the court. Everything is being recorded. It is usually not in your best interest to discuss the facts of the case, because the state can utilize any statements that are made now in open court against you in any subsequent or future proceedings. If you are represented by a private attorney, when you come to the podium, so indicate. If they're not here in the courtroom, we'll inquire. If we can try and get them on the phone, I'm glad to do that. Otherwise, the Public Defender's Office for the 17th Judicial Circuit will be representing everybody for the purposes of the limited proceedings of first appearance this morning.
Your Honor, the jail is wondering if you could call Casey Mulhall, that attorney's at the very end of this morning's docket.
And the reason for that is?
He's in a wheelchair, Judge.
Mulhall?
Mr. Mulhall is here present as a main.
Mr. Clerk, what is this?
Oh, this is for the case that they call out of.
He's here a main, Judge.
Yes, sir.
Too much money?
Mr. Clerk, the name is similar but not the same name. Okay, that's why we take a look at everything. Mr. Mulhall, good morning, sir. You have new substantive charges: possession of heroin, possession of cocaine, possession of a prazolam, and a city ordinance. I do find probable cause as to each respective count. Was Mr. Mulhall interviewed for pretrial?
Yes, he was, Your Honor. Based on his criminal history, we do not believe that he's a good candidate.
What do you?
Out of the state of Florida, battery on a law enforcement officer and resisting in 2012. Out of the state of Colorado, DUI in 2012. Another DUI and a failing to repair. Criminal mischief also. He also has priors out of California. Your Honor, I see a domestic violence battery in the state of Florida. Violation of injunction and so forth, Your Honor.
Thank you, ma'am. Bond will be set at $1,000 count 1, $1,000 count 2, $1,000 count 3, and $25 count 4. Have a good day, sir.
Judge, respectfully, and speaking Mr. Mulhall, he's 35 years old, been residing here his whole life. He says he lives with his father in Hollywood. However, financially, he says he can't afford to post bond. He's respectfully asking you to consider pretrial.
For the reasons already stated on the record, pretrial is declined. Bonds will remain as stated. Have a good day, sir.
Okay, Judge.
Cheryl.
Well, the reason why I asked is we couldn't hear anything what pretrial was saying, and Mr. Mulhall couldn't hear anything what pretrial was saying.
Based upon numerous prior criminal history. Have a good day, sir. Cheryl Seebeck.
Call around, Your Honor.
Good morning, Ms. Seebeck. You have an out-of-state hold under case number 0902065G. I do find probable cause. Bond is set at no bond. Have a good day, ma'am. Chantel Thompson.
Your Honor, Chantel Thompson will be a reset for the pen. She's claiming wrong person.
Chantel Thompson will be reset to this afternoon, claiming that she's the wrong person. Aquino Johnson.
She's here approaching, Judge, to decline the service of public defender.
Good morning, Ms. Johnson. You representing yourself this morning?
I guess so, because my family attorney is not here with me.
Who is your attorney, ma'am?
I don't know their name. My mother has all that information.
When do you think the attorney will be available? You want to put this over to this afternoon and give your lawyer a little bit more time?
I cannot hear you. What
Yes.
did you say?
Would you like me to put this over to the 1:30 docket to give you some more time?
Can I just sign with one of the public attorneys
Yes, ma'am. It's your decision.
for right now? And can I change my lawyer later?
You can do that, or if you want, I'll put this over to 1:30 and we can address it at that time.
All right, that's fine, sir.
Okay, we'll see you back at 1:30. Thank you. Catherine Jarrell?
She's in court, Your Honor.
Do we know if she's in court for the misdemeanor case that this warrant was issued for?
This is the ones I already went through. I don't believe so, Judge.
She has a no bond VOP. She might be in court for that. I'm inclined to agree with Mr. Linder. It probably is not for the charge that's in front of the court now.
Should we set it over for tomorrow or this afternoon?
Let's try. We could try for this afternoon.
Okay.
I mean, if she resolves her violation of probation, it's possible she
Well,
could
the
resolve
problem
this
is-
also.
But the problem is that the paperwork probably won't be posted in the computer, so this afternoon might be a little ambitious, although we're trying. Let's put it over till tomorrow morning.
All right, Judge.
Thank you. Valerie Zajerski?
Yes, no fraud, Your Honor.
Ms. Zajerski, you have a new substantive charge of trespass. I do find probable cause. Do you have any charges pending anywhere under any name? Besides, are you on probation for anything?
No.
State have an offer?
Offer be adjudication, time served, Your Honor.
Ma'am, if you'd like to get the case over with today, and it's certainly, I don't know the facts and circumstances beyond the allegations, I'll adjudicate time served, impose court costs, and give you 6 months to pay the court costs. If you want to maintain your innocence, then we'll address your custodial status. I don't want you entering a plea just because you'll be getting out.
Judge, Ms. Zaberski indicated to me earlier this morning that she does want to resolve the case.
Okay. How do you wish to plead, ma'am? Guilty, no contest?
I don't know, whatever, no contest, I guess, I don't
Okay,
know.
adjudicate time served and court costs, 6 months in which to pay. Have a good day, ma'am. Thank you.
Okay, thank you, bye.
Thank you, Mr. Reedy. Angela Amonte.
No fraud.
Good morning, Judge.
Good morning.
Good morning, counsel. Ms. Amonte, you have a charge, a capias for municipal ordinance violation. Counsel, do you, let's see,
Yes, George
it
Order
looks like it's for a petty theft?
Yes, Judge. George Order, for the record, standing in on behalf of Mr. McLawrence. I believe Ms. Amante is indigent, but I'm asking the court to declare her indigent and appoint him to her case. And we'll proceed from there.
I'm sorry, sir, I can't hear you.
I'm asking the court to declare Ms. Amante indigent and appoint Mr. McLawrence to her case.
Ms. Amonte, do you have any money to hire an attorney?
No, sir.
Okay, Mr. McLawrence is appointed as on the case. Yes, counsel?
Yes, Judge, I would ask the court to consider a withholding court cost, being that it is a petty theft, and I believe Ms. Amante may have a previous theft in her past, so we don't want to have this trickle into two or more subsequent events if she picks up a third and turn it into a felony, if the state chooses to pursue it that way.
Am I incorrect? I was under the, I seem to recall, and candidly, it's been a while since I actually addressed the issue, but I was under the impression that even the withhold would still allow for an enhancement.
No, it has to be an adjudication.
I'm sorry?
To my knowledge, it needs to be an adjudication unless they change.
No, that's what, honestly, I was under the same impression that withholds can count also, but I'm not 100% positive.
I'm going to decline to convey a plea because I believe, I believe we're disagreeing on the law, and I don't feel particularly comfortable. If there is a prior, then the next one could be prosecuted as a felony. Counsel, do you care to be heard on the amount of the bond?
Yes, Judge, I would ask, she has no funds. If the court can inquire as to she has a valid place to stay in a residence, I'd ask the court to just all on this and allow her to come back to court.
Counsel is your client. You're welcome to make the inquiry.
Oh, thank you, Judge. Ms. Lamonte, how are you doing this morning?
Okay, sir.
Okay, do you have a valid address here in Broward County?
Yes.
Okay.
Yes, sir. 2755 Northwest 9th Court.
Who stays there?
Me and my friend.
How long you been living there?
For about, 12 years, sir?
How long you been in Broward County?
Over 30.
If the court releases you on your own reconnaissance, will you return to any court appearances declared by this court?
Yes, sir. Yes, definitely.
Well, there's an allegation you didn't show up last time. You're gonna check the mail a little bit more closely in the future?
Yes, I will. Yes, I will. Yes, I will, sir.
Counsel,
Yes.
are you moving for an ROR?
I am, Judge.
That is granted, sir.
Thank you, Judge.
Thank you, Ms. Monte. Your lawyer's done a good job for you. Make sure you stay in.
Thank you.
Make sure you follow up on this, though, and get this taken care of, okay?
Okay, thank you, sir.
Counsel, any other cases this morning?
There's 3, 6, 7. You want to
Okay.
do them all now? Or
No, let's just go ahead and go
Okay.
straight through then. I'm sorry. Rashay Hemans?
Judge, I'm informed she bonded.
Thank you. Carolina Gallego?
Yes, Your Honor.
Good morning, Ms. Gallego. You have a warrant for on the case number 170335562, PC 30, driving while license suspended. I do find probable cause.
Because I don't know if Ms. Gallego would be interested in resolving the case this morning. I don't know her driving history.
Your Honor, her bond has been posted.
Your bond has been posted. You're out.
Ms. Gallego, we've been informed that your bond has been posted. Bond is $500. Have a good day, ma'am.
Thank you, same to you.
Okay, Tiffany Jane Cox.
What is the middle name? Good morning, sir.
Good morning, Ms. Cox. You have two warrants on the misdemeanors on the case number 17029-256 TC20A. Leaving the scene of accident and driving while license suspended.
Your Honor, this was a person yesterday that the court asked pretrial to interview to see if she had residence so that she could return. Following the court's directive, we did make contact. We interviewed her, and then we spoke with her mother, Jen C. Cox, yesterday afternoon at 2:54 p.m., at which time her mother advised that the client has not resided with her for the past 3 months, and at this time will not be allowed to return to her residence. The only thing her mother wanted to know from the pretrial interviewer was where her vehicle is, because she said the client was driving a vehicle of hers and she wants it back.
Thank you, pretrial,
You're
for
very welcome.
such a complete rendition of all the efforts that you undertook on my request. Bond will remain, yesterday the bond was $1,000 counts 1 and 2. I reduced it to $500 counts 1 and 2. The bond will remain $500 counts 1 and 2. Have a good day, ma'am. Tamishva Denmark. Tamishva Denmark.
She's present here at Maine.
Your Honor.
Ms. Denmark, you have 2 counts of burglary with an assault or battery warrant.
Your Honor.
Yes, sir.
Before we start, I spoke with the mother of the both alleged victims, one of which is a juvenile. She would like to address the court. She couldn't be here this morning, so if we could reset this for 1:30, please.
Okay, we'll reset for 1:30 to give the victim opportunity to be heard.
So if you have a copy of the probable cause affidavit, Mr. Linder, I'd appreciate a chance to look at that between now and then.
Tatiana Herrera.
Ms. Herrera is approaching.
Good morning, Ms. Herrera. You have a warrant for violation of community control. I do find probable cause. Bond is set at no bond. Your next hearing is on August 28th at 9 a.m. Have a good day, ma'am.
Thank you, Judge.
Jessica Young.
What's that? Okay.
North Broward, Your Honor.
I was talking about.
Good morning, Ms. Young. You have a violation of probation warrant under case number 16006677 CF10A. Bond is set at no bond. Your next hearing is on August 29th at 8:45 a.m. Have a good day, ma'am.
You too.
Joy Roberge.
North Broward, Your Honor.
Good morning, Ms. Roberge. You have a warrant for violation of probation under case number 15003781 CF10A. Bond is set at no bond. Your next hearing is on August 28th at 9 a.m. Have a good day, ma'am.
Thank you, you too.
Teresa Hunt.
She's here present, Maine.
Yeah. Well,
Good morning, Ms. Hunt. You have a violation of probation warrant under case number 09-12635 CF10A. Bond is set in the amount of no bond. Your next hearing is on August 28th at 8:30 a.m. Have a good day, ma'am. Elizabeth Kane.
She's in North Broward, Judge.
Good morning, Ms. Kane. You have a new substantive charge of grand theft from Walmart. I do find probable cause. Was Ms. Kane interviewed for pretrial?
Yes, Ms. Kane was interviewed based on her criminal record. 2015 grand theft adjudication, burglary of an unoccupied structure adjudication. 2014 leaving the scene of an accident with vehicle damage adjudication. Petty theft in 2014 adjudication. Possession of cocaine in 2012 adjudication. She does have more prior. She's been to state prison a couple of times.
Thank you. Thank you. Pretrial bond will be set at $1,000.
Your Honor, Ms. Kane has been living here in South Florida for all of her life. She does have family here. Admittedly, she doesn't have the best record, but she has been living in the same location for 20 years or more. She's provided me with the name and number of her father, who is currently out of town, who she believes will help post bond. She's not sure exactly how much money he'll be able to come up with. I'd ask the court, based on the fact that she does have a long-standing history here in South Florida, that the court consider a $500 bond for her.
State care to be heard.
Your Honor, I think the $1,000 bond is fair because her long-standing criminal history as well, I think, balance them out, that there certainly isn't anything. The mitigation doesn't outweigh the aggravating factors.
Considering the argument of respective counsel, the facts of the case, and the applicable law, bond is set at $1,000. Have a good day, ma'am.
Thank you.
I'll call your dad.
Johnson.
Shantoria Johnson, I believe we already addressed you. Reset it for the PM.
That was Temishiva, Denmark.
Ms. Johnson was the first person that was addressed. She was the one that, Your Honor, inquired as far as if she was going to hire private counsel. She said she had that intention.
No, yeah, you brought the wrong person then.
Yeah, you have the wrong Johnson, I think, Mr. Ramiro. And I don't say that lightly. We've got...
Well, it was...
We have Aquendo Johnson was the one that was the extradition hold that was reset.
Come on up. Come back here, Mr. Shantoria Johnson. I know. I know they had a conversation with you already. Judge, this is Shantoria Johnson, the first person that was called.
Well, can I get the...
They got the wrong one.
Can I get the first one that we had with Ms. Johnson? Thank you, sir. You're Ms. Shantoria Johnson?
Yes.
Correct.
Okay. You declined the public defender because you believe that you're going to have private counsel and your family's working on it?
Yeah, I thought so, but as you told me earlier, I can sign with them and then change it later.
Well, we're going to see you back at 1:30 to give your family the opportunity to retain counsel. I need Aquendo Geno Johnson.
It's the same things before, just we now know the right charges.
have an Aquindo Jeno Johnson.
Check to see where she is.
There's no one by that name here at Maine.
There are other jails.
What page is it? Or you have arrest number, page number? Because it's hard hearing.
Your Honor, if I may.
Yes,
He's
sir?
at Maine Jail. Aquindo Johnson. I'm showing he's at Maine Jail on an out-of-state hold.
It's a male.
Yeah.
It's a page 2.
All right, here's the arrest number.
Okay, there.
371
371
700
700
140.
140 700 140. Okay, they've located him, 2C1, they're going ahead and bringing him.
Then we'll put that on a recall, thank you. For Alethea Amy Cruz.
She's here, President Judge of Maine.
Good morning, Ms. Cruz. You're charged with possession of cocaine, paraphernalia, and a county ordinance. I do find probable cause as to each count. Was Ms. Cruz interviewed for pretrial?
Ms. Cruz did not want to be interviewed for pretrial.
Ms.
Ms. Cruz
Cruz
does have
Ms.
a lengthy history, Your Honor. 2016 prostitution, 2015 possession of cocaine. I see in the last 10 years, 6 adjudications for possession of cocaine, Your Honor.
You don't have a microphone on there, do you? Oh, you do?
It's right here. But the PD always can't hear certain
I
things.
just wanted to make sure Mr. Romero was able to hear.
Yeah.
Miss,
I appreciate that,
He
Judge.
hears some things and some things he doesn't.
Miss,
I know last week we heard pretrial. This week, for some reason, we're having that problem again.
that's, we'll get it. Okay, pretrial indicated that there's a lengthy criminal record and that Ms. Cruz declined to be interviewed for pretrial. Bond is set at 1,000 count 1, 300 count 3. Have a good day, ma'am. Alexis Burgess.
Ms. Burgess, come on up, please.
Good morning, Ms. Burgess. You have a warrant for violation of probation. Bond is set at no bond. Your next hearing is September 8th at 8:45 a.m. Have a good day, ma'am.
Good luck.
Sierra Twitty.
Ms. Twitty, come on up, please. Judge, in speaking with Ms. Twitty, she informed me that her family will be posting her bond.
Your Honor.
And she wasn't considered for pretrial because of her pending grand theft.
That's
why she's so quick to go.
That's what I was going to address, Your Honor.
Yes, sir.
Assuming the court finds probable cause, I
Find probable cause as to each count. Bond is, yes, sir?
Ms. Twitty does have a pending grand theft. She also has a 2014 grand theft and petty theft where she violated probation. Because this arrest would violate her pretrial release conditions, state is seeking a bond increase on count 1 to $2,500.
I'm going to leave the bond in place at $1,750. If the family's already making arrangements, if that's the representation, I'm not going to disturb it.
Thank you, Judge.
Genova Albuquerque.
No, brought, Your Honor. She's still a medical reset.
She's been a medical reset for about 8
Judge, I think we're gonna just have to send her to her division. She's been a medical reset, and if you want to go off the record or sidebar, I'll tell you why.
Is there, would that, beyond your representation, which I certainly will accept, are there any facts that I need to be made aware of to determine what decision to make? If you're saying to send it to division, I don't have a problem with that.
I would ask you to send it to the division.
Any objection by the state?
None.
Okay, send it to the division. Thank you. Kevin Semanis?
Yes, Your President. My family's supposed to be posting my bond. They should have been posted this morning at 7 o'clock. If not, can I come back tomorrow, resolve it?
This is a municipal ordinance case, Judge.
Yes, sir. It's a municipal ordinance case. The bond is $100. We'll leave the bond at $100 and
If not, can I come back tomorrow if they don't post the bond?
it'll come up later in the week. It might not be tomorrow. It'll probably come up early next week.
Okay, thank you.
Okay? Thank you, sir. Good luck.
Judge, they brought over Mr. Aquindo Johnson. So he's here present. Whenever you're ready, we can address him.
Quindo Geno Johnson.
Mr. Johnson, come on up, please. Sorry.
Mr. Johnson, you have an out-of-state hold under case number 1751232. The bond is set at no bond. Have a good day, sir. Daniel Rodriguez.
Good luck. You have a no bond hold, out of state. Mr. Daniel Rodriguez is here present, Judge. This is a municipal ordinance case.
Mr. Rodriguez, you have a warrant on a misdemeanor.
Can you ask if I can close it out?
It looks like a noise violation. Your bond is set at $100, sir. Have a good day.
Can I close it out today?
Let me see if I can take a look at the charging document. Give us a moment. We're getting close, Mr. Rodriguez. Just hold on a second. Looks like you missed court in October of 2016, and then you missed court again in June of 2016.
Yeah, because I didn't get the bond. I didn't get the notice in the mail.
And then you missed court again in June of 2017.
I never got anything in the mail.
Okay.
Last time the judge said the same thing.
Okay, let's see.
He said it was rejected by the mailman. No, I swear. No, I've been checking out.
Hold on a second.
I think I have an idea.
Yeah. No, if I would have known, I would have showed up, you know?
Who's this? Just curious. Let's see.
Mr. Rodriguez, do you have any other charges pending anywhere under any name?
No.
Are you on probation for anything?
No.
It appears from reviewing the court file that this is loud noise from speakers that occurred back in 2016. Is that correct?
Yes.
And you've been arrested twice for this already?
No.
Oh, your capias issued twice, though, for not appearing previously.
Oh, okay. Yeah, because I came here one time, I was at a warrant, and they didn't mail it to the right mailing address.
Okay.
And the judge asked me for the right mailing address, and I gave him my right mailing address. And
So now you would like to get this over with today, is that correct?
Yes.
If you enter a plea of no contest, I'll accept the plea, sentence you to time served, impose court costs, and give you 6 months to pay the court costs.
Thank you.
How do you wish to plead, sir?
Oh, no, guilty. No contest.
No contest, adjudicate time served, court costs, 6 months in which to pay. Have a good day, sir.
All right.
Kevin Yard.
On it again, Your Honor.
Mr. Yard, do you have funds to hire an attorney, sir?
No, sir.
Would you like
to try to resolve this?
Would you like the services of an attorney?
No, sir. I just want to resolve this today.
Do you have any other charges pending anywhere under any name?
No, sir.
If you enter a plea of no contest, I'll adjudicate time served, impose court costs, and give you 6 months to pay. Are you interested in that plea, officer?
Yes, sir.
How do you wish to plead?
No contest.
Adjudicate time served, 6 months in which to pay the court costs. Denny Burwell.
Yep.
Good morning, Mr. Burwell. Do you have funds to hire an attorney?
No.
Are you interested in having an attorney appointed to represent you?
No. Just like to resolve it today if possible.
Do you have any charges pending anywhere under any name?
No, sir.
Are you on probation for anything?
No, sir.
How do you wish to plead? You enter a plea of
contest.
adjudicate time served, court costs, 6 months in which to pay any of the court costs that are imposed. Have a good day, sir.
Thank you.
Ignacio Garay. Mr. Garay, you have a warrant for a misdemeanor, trespass on private property. I do find probable cause. Bond is set in the amount of $100. Have a good day, sir. Richard Crump. Mr. Crump, do you have money to hire an attorney?
No, sir.
Are you interested in having an attorney appointed to represent you?
I'd like to get it resolved today.
Okay. I'll adjudicate time served. How do you wish to plead? Guilty or no contest?
No contest.
Adjudicate time served, court costs, 6 months in which to pay. Have a good day, sir.
Thank you, sir.
Kevin Kane.
Mr. Kane, come on up.
Good morning, Mr. Kane. You're charged with trespass. I do find probable cause. Bond is set in the amount of $25. Have a good day, sir. Luis Castillo.
Judge, in speaking, Mr. Kane, I do not believe he can post his bond. What I'm right now trying to inquire is where he lives. Considering this is a misdemeanor offense, non-violent, I'd be asking to consider an ROR. Henderson? Judge, he's a Henderson patient.
Well, if he's a Henderson patient, I'm going to leave the $25 bond in place and transfer it to Judge Lerner Wren's division. Thank you for the additional information. Luis Castillo.
What did you do on Kane? Oh, he's having a mental health.
Mr. Castillo, for that one, sir. Thank you, sir.
Mr. Castillo, you're charged with possession of cannabis. I do find probable cause. Bond is set in the amount of $100. Have a good day, sir. Nerio Moran.
Judge,
Yes, sir.
regarding Mr. Castillo.
Okay,
he's
you
advised
need
me
to
with
jump in a
Mr.
little bit quicker. We have a pretty big docket today, so we're kind of short, you know, so we want to get everybody kind of taken care of. Yes, sir, go ahead.
Well, I don't want to interrupt you before.
Oh, you can always interrupt me.
Okay, I'll interrupt you.
I'm not that sensitive.
Judge, he wants to know if he can resolve his case.
State, do you have a plea offer?
State would offer withhold. I don't see any priors, Your Honor, and I would be offering withhold court cost judicial notice of time served.
No priors?
I don't see any.
Mr. Castillo, I would accept the recommendation of the state, which is a withhold adjudication and court costs. The concern is, though, you would still have a criminal record as a result of this incident, and the state believes, based upon their limited review, you do not have a criminal record. If you go to the division and handle this case, you may very well be eligible for a program that allows for these charges to be dismissed and have no criminal record from this. I would strongly encourage you to consider going to that type of program because you don't know how this could affect you in the future.
Yes, sir. Yes, Your Honor.
Okay, the bond will be set at $100. Have a good day, sir.
Judge, respectfully, then, considering this is his first offense.
Yes, sir. That's granted. ROR.
ROR, thank you.
Judge, Mayor, I'm out of uniform. I apologize.
Yes, sir.
I call from the family. My name is Louis Peranti. For the record, Judge, on page 21 is Angel Serrato, C-E-R-R-A-T-O. It's just a violation situation.
Hold on. Let us get the paperwork.
Sorry.
What's the defendant's last name?
Serrato, C-E-R-R-A-T-O.
Angel, your attorney here present. Mr. Peranti.
Can they hear me in there? Mr. Serrato, can you hear me?
Yeah.
Okay.
Yes.
Your mother reached out to me yesterday. I've been retained as your lawyer. Okay. So, just we're gonna get a date for you for a first VOP, and that you'll have that date. I'll be there. I'm not gonna look like the way I look right now, but just hang tight, and you're invoking your right to remain silent. You're not talking to anybody. You understand?
All right.
All right.
Okay, wait a second. Let us get caught up on this end. Is it still pouring out?
It was when I left, sir. Hence my appearance, and I didn't know this was going to happen until I got a call from the family this morning.
I appreciate you being here.
I hustle, Judge. I always have. That's a long story, Mr. Reedy.
Angel Serrato?
Yes.
Okay.
It's nice to see you, Judge, by the way.
Nice to see you as well. State, do you have your paperwork?
Yes, I do.
Mr. Serrato, you have 3 violation of probation warrants. I do find probable cause. The next hearing is set for 8/29 at 9 a.m. unless you're able to get it moved up.
No, that's a good day because I'm going to be in federal court on the 28th, so the 29th is fine. It's going to be in front of Judge Lynch, I believe, Judge.
Yes, sir. Anything else this morning?
No, sir.
Okay, Mr. Serrato, your counsel is on board. He'll represent you on this matter. Any questions of me? Have a good day, sir.
All right,
thank you, sir.
I got you, Angel.
Okay. Nerio Moran?
Your Honor, he was deleted from
He's
the
here
docket.
present, Judge Amin.
He was?
Deleted from the docket. It's a court order. He was remanded before his division judge. Yeah.
So this is being deleted and being taken up in the division?
Yes.
I'm being advised by the jail this is being deleted from the docket and being taken up in the division. Do we know when that's going to occur?
Okay, I'll tell him to contact Cindy to get the chrome, because that's I guess the only additional information he would need to request it. Yeah, okay, I'll let him know. Gotcha. But those are still electronically recorded, right? Okay, okay. Yeah. Okay.
So this is in drug court with Judge Zeller?
Yeah.
All right, I'm gonna let him know so you don't have to deal with it. 'Cause
Oh, wait.
I wish I didn't have to deal with it. All right.
Oh, he's to remain in custody until he completes SAP. Upon completion of SAP, he'll be ROR.
And
I'll never tell you that again.
so we're not supposed to address the no bond pending completion of SAP?
No, once
sorry,
he
hold on a
completes
sec.
SAP, he'll be released.
He's ROR'd immediately. It was Judge Zeller's intention that he complete the SAP program, and that I imagine that's why she kept it.
How long is the SAP program?
It's a 30-day program. I mean, I don't know what he's gonna get in, but once the program starts, it's 30 days. I imagine she set it at no bond to prevent the ability to bond to short-circuit the SAP program and get out while it's going on. I mean, she did, I don't know, do you have the order attached, Your Honor?
I do,
Okay.
and, you know, Judge Zeller does wonderful work and helps people, and she has a lot of knowledge and resources, and, defense care to be heard on this?
Because he was at.
Mr. Romero, anything you wanted to say?
Oh, we couldn't hear what's going on.
He's going to be released after he completes the SAP program.
That's what he informed me. He got remanded, I believe, yesterday in custody.
Okay.
Judge Zeller ordered him to complete the SAP program. He's inquiring. I know there's a wait list. He wanted to know how long the wait list is. I told him I didn't have that answer. I don't know if confinement status has that answer.
I believe confinement status gave all the answer that she had.
We don't seem to know.
They don't know.
Okay, I made a note on the booking, on the finding sheet, defendant to be released after completion of the SAP program. I wish you good luck, sir.
Just to let you know, he was remanded yesterday before Judge Zeller, so she's aware of all that is going on with him.
Well, I feel a little bit more comfortable with all the rest of this background information.
Okay.
But just holding somebody on misdemeanors with no bond, I don't feel comfortable with. But Mr. Moran is in Judge Zeller's drug court
Yes, he is.
program. There's a quid pro quo. There's
Okay,
extra burdens on Mr. Moran, but then there's an extra benefit at the end of the program. So having that information, I feel comfortable with it. I made a notation, defendant to be released after completion of the SAP program. Anything else? Have a good day, sir. Good luck in the program. Marcus Ewing?
He bonded.
Breon Farrow? Mr. Farrow, do you have an attorney, sir?
No, sir.
Do you have money to hire an attorney?
No, sir.
Do you want the services of an attorney appointed? Do you want an attorney appointed to represent you in this matter?
Point one.
Counsel, your office is appointed?
Your Honor, I would ask the court, it appears to be a convenience store located in the city of Fort Lauderdale. I would ask the court to consider adjudication time served in the matter, and of course, no return, and court costs with no return to ARIF. I don't know if that's I think that's the name of the manager. I don't know the name of the store, but I'm sure.
Maybe the Blue Store?
I think so, but I'm just not 100% certain, but I'm sure Mr. Farrow knows the store.
Can anybody give me any idea what, if there are any priors?
I can let the court know if he has prior Broward offenses. I would just need his, or if you have his BCCN number.
770047.
Your Honor, I'm showing a attempted strong-arm robbery from 2013, misdemeanor possession controlled substance 2013, 2013 trespass, grand theft 2010, 3-year state prison, grand theft 2010 with a VOP, 3-year state prison, 2010 burglary of a dwelling, grand theft resisting without violence with a VOP. He received the same prison sentence concurrent. He was sent.
Thank you, Mr. Linder. Based upon at least that portion of the criminal history, I decline to convey a plea offer at this time. Bond will remain at $25. Have a good day, sir.
Thank you, Judge.
Naraya Ari.
Yes, Your Honor.
Mr. Ari, you have a municipal ordinance violation as disorderly conduct.
Yes, sir.
Do you have funds to hire an attorney?
No, the city attorney.
Okay. Would you like an attorney appointed to represent you?
Yeah, city attorney will work fine.
The office of Mr. McLawrence is appointed to represent Mr. Ari. Counsel?
Judge, thank you, Judge. Joe Jordan on behalf of Mr. McLaurin. Same on this one. I'm asking the court to get involved with adjudication, time served, court costs. It appears to be panhandling.
I got it. Mr. Ari, do you have any other charges pending under any name?
No, sir.
Are you currently on probation?
No, sir.
Your attorney is asking for an adjudication, time served, and court costs. Are you interested in that?
Yes, sir.
How do you wish to plead, guilty or no contest?
No contest, Your Honor.
Counsel, I'll accept your request, adjudicate time served, court costs, 6 months in which to pay.
All right, thank you.
Have a good day, sir. Louis Joseph.
Mr. Joseph is approaching, Judge. Judge, Mr. Joseph has a $100 bond. My understanding is, I believe this may be his first contact with the criminal justice system. He's 30 years old. Respectfully, then I'd be asking you to consider an ROR if the state can verify that.
State care to be heard?
No, Your Honor, I don't see any prior Broward history.
State care to be heard on the request for an ROR?
No, I have no objection, Your Honor.
Okay, without objection by the state, ROR, I do find probable cause, and ROR is granted. Have a good day, sir. Willie McLeod?
Mr. McLeod, come on up, please. He's here approaching, Judge. He's here at main, Judge. He's wanting to ask the court to consider resolving his case today for time served. Come on up, sir.
State care to be heard?
On Mr. McLeod?
Yes, sir.
As far as, I'm sorry, Your Honor.
The defense is requesting a resolution today for time served. Is that correct, Mr. Romero?
Correct, Judge.
The only thing I have to check, Your Honor, because it's the language on the booking is a little confusing. It mentions operating, but it also mentions with a suspended driver's license. So
The probable cause affidavit indicates that the defendant, Mr. McLeod, was indicated loitering behind a discount auto parts. teletype revealed an active warrant for driving without a valid license.
Yeah,
You wanna see about the original charge?
I just want to make sure, since if it's
Yes, sir, go ahead.
suspended, obviously there can be ramifications.
It looks like there are still 6 active suspensions for failing to pay and failing to appear.
Do you have his driving record, Judge?
Yes, sir. Come on, I'll give it to you.
Because it does look like, from what I can tell, he's charged with DWLS. Thank you, Judge.
Take your time, Mr. Linder.
It's been a little while, but... Your Honor, it appears this would be a second, but first within a 5-year period, so the state's offer would be adjudication time served.
My confusion here is, it looks to me, that Mr. McLeod has already been.
What was that, Judge?
My confusion here, it looks to me like Mr. McLeod may have already been to court on this case.
Can't hear. I can't.
It looks to me like Mr. McLeod may have already been to court on this case. Mr. Clerk, can you look up on the clerk's computer? Because I'm seeing.
Your Honor, I'm showing he failed to appear as arraignment on January 12th.
Is that what it is?
Yes, and that's when the CAPE, and I'm looking, that's when the CAPE use was issued.
Okay. All right. I just don't want him to have to pay twice for the same case.
No, of course.
Okay. Mr. Romero, if Mr. McLeod's interested, I'll adjudicate time served and impose court costs and 6 months in which to pay.
You wish to accept the judge's offer, adjudication time? Yes, Judge, he wishes to accept your offer.
Now, Mr. McLeod, you also need to understand that if you get 3 suspended driver's license charges, the third or the next one could possibly be prosecuted as a felony. Do you understand that?
Yes, sir.
Now, if you want to get out on this case and have your day in court, well, I'm glad to take a look at the bond and possibly lower it. I don't want you to enter a plea just so that you're getting out today. Do you understand that? Now, if you want to take care of it today, I'm glad to do that as well.
I'm ready to take care of it today, sir.
Guilty or no contest?
No contest.
Okay, adjudicate time served, court costs, 6 months in which to pay. Have a good day, Mr. McLeod.
Thank you, sir.
Willie Grayson.
Mr. Grayson is here approaching, Judge. And Mr. Grayson is inquiring if Your Honor would consider resolving his case today.
State have a plea offer?
One moment, Your Honor.
Take your time.
Your Honor, reviewing Mr. Grayson's criminal history, and just to note the most recent 2011 delivery of cocaine, possession of cocaine, 47-month state prison as a habitual offender. Before that, trespass 2011, trespass 2010, theft 2010, a long drug history and theft history going before that. And based on these specific allegations, Your Honor, state's offered to be an adjudication 5 days. To run concurrently on both counts.
Mr. Romero, is Mr. Grayson interested in resolving today at 5 days?
Judge, that's what I just finished telling him, that the state's suggesting 5. He has credit for 1, so he'd be doing about 4 days. But also what I heard from the state is, I know he's been incarcerated, he went to prison, and he got released, I believe, 2012. So he's been clean for about 5 years now, Judge. You wouldn't entertain reducing the 5 days, would you, Judge?
If it's an open plea, it probably does not get better.
Oh, no, we wouldn't do an open plea, Judge. Let me talk to him.
Yes, sir. Also, Mr. Reedy, did you have the opportunity to review the probable cause affidavit?
Yes, I did, Judge.
Judge, in speaking with Mr. Grayson, he wishes to accept the state's offer.
Mr. Reedy, is there anything you'd like to be heard on?
Well, as far as the resisting arrest without violence,
I was looking more at the paraphernalia.
you know, I guess he has a silver grinder containing a green leafy untested substance.
Yes, sir. Mr. Romero, let me just so this is on the record so that everybody's on the same page. The probable cause affidavit in the last paragraph, as it pertains to the possession of paraphernalia, a search of the black backpack in defendant's possession produced a large silver grinder containing a green leafy substance. It does not indicate that the substance was tested in any way. If Mr. Grayson still wants to go ahead and accept a plea, I'm glad I will accept it and impose the 5 days.
Judge, then having said that, as far as I don't know if Your Honor has determined whether or not there's probable cause yet on this case, but taking into account that potentially there may be a probable cause argument, would Your Honor then consider an ROR? He hasn't been in trouble for like 5 years. It's a misdemeanor offense.
I would ROR on the paraphernalia, finding no probable cause, but I would put a $100 bond on count 2, the resisting.
So you would switch the 100 from top to down?
Well, there is probable cause for the resisting. I'm concerned about the probable cause for the paraphernalia.
And, Your Honor, for the record, my greater concern is with the allegations having to do with the resisting without violence than the paraphernalia, or the obstruction element.
I was explaining to Mr. Grayson right now that he could have his day in court and fight it. I did advise him that I requested an ROR. Your Honor indicated to the contrary. I believe Mr. Grayson is still telling me that he wants to proceed forward and resolve the case and accept the state's offer, Judge.
Is that what you want to do, Mr. Grayson?
Yes, Your Honor. That's a shame. Lord have mercy.
Then you shouldn't accept it if you're in it.
I'll stay in jail long. I don't want to.
Judge, it's against counsel's advice. I don't know if you wish to inquire what Mr. Grayson would want to do as judge.
Mr. Gray, well,
You gonna give me time, sir? All I wanted.
well, Mr. Grayson, even if count one was not involved in this, based on the resisting and the priors, I would think a 5-day sentence is still a very reasonable offer to be made for you on that count. Well, you're pleading no contest, or you want to litigate this in court?
I'll accept the 5 days, Your Honor.
Guilty or no contest, sir? Do you plead guilty?
No contest.
Okay, I accept the plea. I also recognize and acknowledge counsel's objection for the record. Adjudicate guilty, time served counts 1 and 2, 5 days Broward County Jail to run concurrent and not consecutive to each other. Each count to get credit for time that's already been served. Court costs, 6 months in which to pay the fines and court costs. Is that acceptable to you, Mr. Grayson?
Yes, Your Honor.
Have a good day, sir. Matthew Morgan.
North Broward, Your Honor.
Oh, what are you saying?
Mr. Morgan, you're charged with a new substantive offense of petty theft. I do find probable cause.
Yes, Your Honor.
Bond is set in the amount of $100. Have a good day, sir.
Stating the obvious.
Jorge Gonzalez.
Gonzalez is a person, Judge? 12.
Good morning, Mr. Gonzalez. You have a warrant for violation of probation. I do find probable cause. Bond is set at $2,500, and your next hearing is on September 6, 2000, at 9 a.m. Have a good day, sir. Gustavo Gomez.
Mr. Gomez, come on up, please.
Mr. Gomez, good morning, sir. You have a warrant for a misdemeanor on the case number 140-65200 TC38. I do find probable cause. Bond is set in the amount of $100. Have a good day, sir. Christopher Floyd.
Mr. Floyd is approaching, Judge. Minutes for warning.
Mr. Floyd, you have a new substantive charge for a municipal ordinance violation from the city of Hollywood. I do find probable cause. Bond is set in the amount of $25. Are you interested in resolving your case today, sir?
Yes, sir.
You enter a plea of no contest. I'll adjudicate time served. I'll give you 6 months to pay the court costs. How do you wish to plead, sir? Guilty, not guilty, no contest?
No contest.
Adjudicate guilty, time served, 6 months to pay the court costs. Have a good day, sir. Taffarol Gordon.
Mr. Gordon is here present, Judge. He's asking me, Your Honor, if you would consider resolving his case today for time served.
Mr. Gordon, you have a capias on a misdemeanor for a pedestrian violation. I do find probable cause. If you're interested in resolving the case, I'll adjudicate time served, give you 6 months to pay the court costs. How do you wish to plead, sir? Guilty, not guilty, no contest?
No contest.
Adjudicate time served, 6 months in which to pay the court costs. Have a good day, sir. Jarrell Hyacinth.
North Broward, Judge.
He's in transit, Your Honor. I don't have him here. Magistrate.
Do you want this to put this on recall or just wait a couple of moments?
I can call intake and see if he made it here yet.
Recall.
We'll put that on recall then, Deputy, and just let us know when you're ready to proceed.
Okay, thank you.
Thank you, sir. Okay. Rory Dixon?
Mr. Dixon's here, President Main Judge. Judge, Mr. Dixon's requesting if you would consider an ROR on his case. At this time, unfortunately, he's not working, he's financially indigent, he's homeless. However, he can receive his mail, his notices at his mom's address. Judge, considering this is a non-violent offense, we'd be asking you to consider an ROR.
Well, Your Honor.
State?
Actually, I don't believe, well, it depends. I'm going to be asking the court to issue an order of no victim contact. And if the court does that, then he won't be able to get his mail at his mother's address because I believe she's the listed victim.
Judge, he says that he has a sister also that lives in Broward County in a different location than his mother. He could use that address to get his notices.
Well, the request for an ROR is declined. I do find probable cause as to each count, and bond is set at $100.
And Your Honor, that's an order of no victim contact.
And no victim contact pending for further order of a court of competent jurisdiction. Have a good day, Mr. Dixon. Lucas Pereira de la Fuente.
I've been advised he bonded.
Thank you.
Gregory Bruno.
Gregory Bruno.
Mr. Bruno's here, President Main, Judge. Judge, I don't know if you've determined if there's probable cause. I'd ask you to allow the defense to speak once you've made that determination.
Still nothing on. Still nothing on.
No, he emailed me. It's not, they're aware of it, but that's it.
Mr. Bruno, I'll certainly give you the opportunity to speak. Everything is being recorded, and anything you say can be used against you in any subsequent proceedings. If you still desire to speak, sir, you can take whatever time you feel is in order.
Judge, actually, I'm going to be speaking on his behalf.
Yes, sir.
If the state can verify, I believe this is his first exposure to the criminal justice system. He lives in Pompano Beach with his parents. He's 20 years old, been residing in South Florida for 3 years. He's a graduate of Piper High School. After finishing Piper High School, he then entered Broward College. He is studying at Broward College. He is seeking a degree in IT. Judge, if the state can verify that this is his first exposure, considering his strong ties to the community, we'd be requesting an ROR on his behalf.
I don't see any criminal history, Judge.
State care to be heard on bond?
Your Honor, with no priors, I don't have an objection. What I wouldn't have an objection, and I'm probably gonna get a look for this, if the court were to place him on pretrial release. I mean, I do have a bit of a concern about knowing what's been going on in that community where he was arrested.
But in fact, there is no evidence to link Mr. Bruno to any.
And believe me, if I was, I wouldn't be saying that I'd be okay with an ROR.
Well, I understand the defense. Not linking Mr. Bruno to the concerns the police have in the area generally. But the facts of the resisting do cause me concern. It could have gotten real ugly. It could have gotten to be a terrible situation, and it's just if the I'm here to accept the allegations within the four corners of the document. This is not a trial. Based on the allegations in the four corners of the document, the court's going to decline ROR and set bond at $2,500. Have a good day, sir.
Your Honor, we can go back on Mr. Hyacinth.
Jarrell Hyacinth?
I heard from the North Broward Detention Center. Apparently, Mr. Hyacinth is currently at the main jail intake.
Oh, never mind. I got it here. I got it.
So I don't know how long it's going to take him to go through that process. Maybe we could reset him for this afternoon and hope that he can join us then.
Yes.
Let's reset to 1:30. We'll take a look at it at that time. Thank you, Mr. Reedy. Roosevelt Goody?
North Broward, Your Honor.
Mr. Goody, good morning, sir. You have 2 warrants for violation of probation on felonies. I do find probable cause as to each. Bond is set at no bond, and your next court date is August 29th at 9 a.m. Have a good day, sir. Johnny O'Halloran.
Oh, I can't resolve a VOP.
Mr. O'Halloran is here, President Judge of Maine.
Mr. O'Halloran, you have warrants for aggravated assault with a deadly weapon, fleeing or attempting to
Excuse
elude.
me, Your Honor, I'm sorry.
Yes, ma'am.
Counsel 1 through 3 were corrected.
Yes, ma'am.
Should be corrected.
So count 1 is aggravated assault of a law enforcement officer. Count 2 is aggravated fleeing and eluding. Count 3 is suspended driver's license. The capias were issued for no show at arraignment. As you find, bond is set at no bond, counts 1 and 2, $25 count 3, and $250 as to count 4.
Actually, I think that was.
It's a not in custody cases for the bond to be set at magistrate.
That was just on the.
The capias for no show at arraignment, correct?
That's just on the municipal ordinance charge, Your Honor, on count 4.
Okay, I'm not following you.
Your Honor, on count 4, on your booking, you should have a count 4.
Correct?
He failed to appear at the arraignment on that charge and got a $250 bond. Counts 1 through 3 are not in custody capiases based on the filing of a non-custody information, and with no bond hold for magistrate so that they can be set here.
I have it. So the no-show at the arraignment was for the misdemeanor?
Yes.
Okay, and the others were the filing of the charge?
Yes.
Got it, okay. Capias having been filed, I do find probable cause as to each count. State have a recommendation for bond for counts 1 and 2?
Yes, Your Honor. First, just noting, Mr. O'Halloran, 2015 misdemeanor possession of cannabis resisting without violence. 2015 tampering with evidence. He violated probation, was sentenced to 180 days county jail. My concerns based on the PC, obviously putting the officers' safety at risk, and also any motorists on the road at that time, considering the allegation that he swerved into oncoming lanes, Your Honor, of traffic on, I believe it was I-95. I'm sorry, on Northwest 28th Avenue, I apologize. Your Honor, the state would be requesting bonds in the amount of $7,500 each on counts 1 and 2. Also noting that when they located the vehicle, that eventually that the tag had been removed, which gives me reason to believe that Mr. O'Halloran might have taken actions to avoid apprehension.
Defense care to be heard?
Speaking of Mr. O'Halloran, he's 21 years old. He's currently employed. He works for a company called Green Ops Landscaping. He's been working for them for about 2 years. Whenever he can get work and the weather permits, he gets paid approximately $100 a day. He lives in Dania Beach with his friend who's been residing in the same location for 2 years. His friend is the person who he's going to be contacting to help post his bond. His friend works as a cashier, salesperson at a store, so therefore his financial resources are limited. What we'd be asking you to consider is setting a $5,000 bond on count 1, $3,000 bond on count 2. That would make it a total of $8,000 on both counts 1 and 2.
Counsel?
Your Honor, George on behalf of Mr. Lawrence, I believe Mr. O'Halloran had one count, a charge, I'm sorry, it's the 4th count on your docket. I'm asking that Mr. McLawrence be appointed to that. It appears since Mr. Romero is speaking on his behalf, he's already been declared indigent.
Mr. O'Halloran, I'm going to try and explain to you what's probably would not make a lot of sense, because I don't know what makes a lot of sense to us, but it's the law and we have to comply with it. The Office of the Public Defender of the 17th Circuit is representing you on counts 1, 2, and 3. Count 4 is a municipal ordinance, and they do not provide representation to you on that count. We do have an attorney here that can represent you on that count. Are you asking for an attorney to be appointed for you on the municipal ordinance violation count, which is count 4?
What the judge explained is on counts 1, 2, and 3, those are state charges. On those state charges, the Office of Public Defender represents you. You filled out the financial affidavit, you wanted to, the clerk's going to make that ultimate decision. However, on count 4, it's a city charge. The municipality of Fort Lauderdale. That gentleman right there is the people that represent people who are indigent. The judge is asking you if you want him appointed on your case to represent you on the city charge on count 4. Yes? He wishes.
Mr. McLawrence's office is appointed to represent Mr. O'Halloran as to count 4.
And Judge, I won't delay the inevitable. I've heard the arguments on both sides. I'm just going to ask the court, however the court rules on counts 1, 2, and 3, would the court be inclined just to RR him on the municipal in this case? We're not seeking to resolve it. We're just going to track the felony counts and try to get them all resolved at one time.
Yes, sir. Any further arguments as to the bond to be set?
Nothing from the state, Judge.
Nothing from the defense, Judge.
And state, I'm sorry, as to priors?
Your Honor, he had a, you know what, I don't want to go based on memory. Let me just pull a just take a moment. He had a 2015 possession of cannabis and resisting without violence. Also in 2015, tampering with or fabricating evidence with a violation of probation, and he was sentenced to 180 days in county jail.
Anything by anybody else? Okay, bond will be set at $7,500 count 1, $7,500 count 2, $25 count 3, and $250 as to count 4. Have a good day, Mr. O'Halloran. Francisco Rivas.
Your Honor, he was removed from the docket. It's a violation of pretrial warrant. Those are for magistrate.
Not yet.
And what about the capiases on 3, 4, and 5?
It's the one and the same.
They're all the same?
Yes.
So where does this go next?
He has a hearing scheduled for 8/28 before his division judge.
So this is not for magistrate?
No.
Okay. Thank you. Okay, Samuel Walker?
Stamp.
Proud.
Mr. Walker, you have a warrant for a violation of probation. I do find probable cause. Bond is set in the amount of, it's under case number 1400578 CF10A. Bond is set at no bond. There's also a capias under a misdemeanor. Bond on that is $500. Your next hearing is on 8/28/17 at 9 a.m. Have a good day, sir.
Your Honor, we have counsel here from the case that was reset from yesterday.
Yes, Ms. Horowitz, which case?
Good morning, Your Honor. Melanie Horowitz, on behalf of Raymond Delmonico. There was a case that was rolled over from yesterday.
Hold on, let's get the paperwork. Is it on the docket?
I didn't see it. As you know, Your Honor, I was here.
Yes, ma'am, let's get the paperwork first.
Okay, of course.
Mr. Clerk, do you have the paperwork for Mr. Delmonico?
Delmonico. D-E-L. Raymond is the first name.
Because you were here yesterday afternoon.
Mr. Clerk, can Ms. Horowitz come up and give you the case, or give you the case number and see if we can get the paperwork if it's not here? You don't have the case number? Yesterday I could understand, but you came here today through the rain and you don't have the case number? Okay.
It's, if I may, Judge.
Yes, sir.
It's actually two different case numbers. One is 163995 CF10A. The other is 167267 CF10A. Yes. I'm just going through this.
If I can step out for a second, and while you're looking that up, I have a judge calling me from Miami.
Yes, ma'am, absolutely. It's gonna take a little bit to get the paperwork.
Shows 828.
Ready, Mr. Clerk? Oh, I'm sorry. Just let me know when you're finished. I can't see the phone over there. Do we know what the afternoon docket looks like?
Not yet. No, he definitely. Well, he definitely wouldn't be on the afternoon docket in Odyssey because they wouldn't have scheduled him for a second look.
Okay.
And unfortunately, sometimes
He would be on
things get lost.
He would be in Odyssey if they're just, he's on no bond.
No, I know. What I'm saying is they have the second look docket on Odyssey. They wouldn't treat it as a second look.
He's scheduled for the 28th.
I know. Oh, I thought you were saying he's not on the afternoon docket in here on Odyssey. Oh, okay. Yeah. Okay, yeah. The other problem is do they have anyone in Conti? Do they have anyone in Conti this morning?
Well, let's get the paperwork first, and then we'll see where we're going.
Yeah, no, the only reason I was asking is because that's where he is. If there's no one there, then I don't know who'd even communicate to bring him this morning.
His lawyer's here. Let's see where we're at.
Of course,
Everybody on the
absolutely.
same page, and we'll go from there.
For that guy? Yeah. He was on the AM. He said he had an attorney, so we reset him for the PM. But said, yeah, no, it has an attorney. The paperwork didn't make it here from the morning to the PM, so we reset it to this morning. The arrest number is 801-701-081.
For both of them cases? Because he had magistrate. Because he had magistrate yesterday. Oh, yeah. Or just now? Court date in front of you. Give me 1 second, Judge.
Yes, sir, take your
Judge,
time.
you want to do one real quick while we're waiting? The jail's looking to get somebody to Judge Bailey's court.
Sure.
We can call Mr. Michael Waterman on page 24, very close to the end of the docket. Apparently, he's got appearing in front of Judge Bailey later this morning, and we'd like to get him out of magistrate court and get him up there.
Andre, no.
Michael.
Michael Waterman.
There's Peterson, Brown, Watley.
Michael Waterman?
Mr. Waterman, come on up, sir. Sir, thank you, Judge, thank you for taking it out of order.
Absolutely. Good morning, Mr. Waterman. You have a warrant under case number 13006698 CF10A for grand theft. Does he have to be in front of, does Mr. Waterman have to be in front of Judge Bailey for this case?
Yes.
Correct.
That's what I understand, Judge, yes.
So bond,
I believe he has a court date this morning, but right now the deputies are waiting on a phone call to see if they transfer him. That's why I just wanted him addressed to see if they get the phone call. He's already been done, so he's free to leave.
The transport order states it was.
the order returning the defendant to court, which was signed by Judge Bailey on July 11th, directs that he be in room 7900, 8:30 a.m. today. So should we just release this to Judge Bailey's division?
I believe.
Yeah, I think
Just
that's fine.
to avoid it. I mean, obviously, if you find probable cause, yeah, then.
Well, let's find probable cause, leave the bond at $1,000.
Absolutely,
And Judge
yes.
Bailey will take care of it, because I don't want, I think what
great.
Mr. Linda's concerned about, if we don't,
He'll come
he may
back.
finish up there, we're still gonna show this open and have to bring him back.
Exactly.
Got it. Good luck, Mr. Waterman.
Thanks, sir. Good luck, sir. Judge, you're not waiting on me for anything, right?
No, sir, Mr. Romero,
Oh, okay.
the clerk is on the phone with their office and references some paperwork for Mr. Delmonico. So I don't want the
Okay.
paperwork, I don't want the paperwork to back up with him, so we're on, like in a holding pattern.
I got nervous because you were looking at me and it was silent. I'm thinking, oh boy, he's waiting on something.
Actually, when I was looking at you, I was thinking I need to give you an update because you can't see what's going on in the courtroom, so.
I can see, but I can't hear.
You should be nervous, Mr. Romero. You should be nervous.
Wait, hold on. That looks like a little hot dog. What's that right there? No, no, that. What's that? I don't like sweet potato. That looks good except for the cheese. No more dairy for me. I don't care for that stuff. Oh, that looks so good. Can't have that. Can't have that. Wait, go back. Where's that? No, to the left. Like, how do you make that? No, to the left.
While the clerk is on the phone trying to get us the paperwork,
That's the question.
did we first appear, Mr. Delmonico, yesterday?
Your Honor, I believe what happened yesterday was
I thought we rolled it over till
we
today.
did. He had it in the morning. He said he had an attorney. The paperwork wasn't here in the afternoon, so you. What? That doesn't look like real. Go up. That left anti. Never mind. I'm sorry.
Yesterday in court
No.
for the violation of probation, he go before his judge August 28th. So there really won't be any paperwork because he was magistrate yesterday.
Well, we had him up for magistrate yesterday.
And it wasn't reset for today, actually.
That looks tremendously unhealthy.
It was supposed to be reset for today. Possibly I made a mistake. I don't know where the breakdown was.
Can't be.
But we tried to put it on for the afternoon.
Stop it.
That didn't happen. Ms. Horowitz came in the afternoon. When I went back to my office up in Deerfield, in between sessions, her office called. When she
Wait,
came in
back
the
up for a
afternoon, he wasn't here, so it was supposed to be back on for today. So he wasn't actually first appeared because he had an attorney, and we were trying to get his attorney present. So has the paperwork already been split up and everything? Is that?
Yeah, most likely, because both of them violations of probation, felony, that division has paperwork.
Okay, so the paperwork's already been sent to the division. Did you hear that, Ms. Horowitz? So, unfortunately, you're gonna have to, at this point, since everything's been sent to the division, get with Judge Shear's division and schedule whatever motions you have pending. Yes, ma'am. As you can see, I'm trying to accommodate you, and it's,
We have someone coming up as far as with the clerk from yesterday who was in court.
well, I think we're fine. I mean, if everything's in Judge Shear's division, let's just go ahead and let Ms. Horowitz go on and tend to other matters, and, she'll deal with Judge Shear's division, okay? Thank you, Ms. Horowitz.
Should I give you my cell phone if there anything changes and when the other person back, or is that what you expected to explain the process, or they?
If you want to just stick around a couple of more minutes, you're welcome to do that.
I do have to go to Judge Cole, so I can stop in and I'll come back.
Well, she's gonna wait like less than 5 minutes, if you can wait. If not, yes, I'll have her call.
Half of something that L'Oreal did. No, I can't have a problem with that. It's meat.
If you're here when the clerk comes up, great. If you want to hit Judge Pole's division, you're welcome to do that, but I want to, people at the jail are getting restless. I don't want them missing lunch because we're trying to do stuff on this end, okay? Okay, Mr. Romero, you still around, or did you leave on us?
Yes, Judge.
Okay, Tavares Peterkin?
Mr. Peterman?
Mr. Peterkin, you have a violation of probation warrant. I do find probable cause under 16005390 CF10A. Bond is no bond. Your next hearing is on 8/29 at 8 a.m. Have a good day, sir.
Good luck, sir.
Barry Donald.
Mr. Donald?
Mr. Donald, you have a violation of probation warrant under 150-13357 CF10A. Bond is set at no bond. Your next hearing is 8/28 at 8:30. Have a good day, sir. Kevin Harrison. Mr. Harris, good morning, Mr. Harrison. You have a violation of probation warrant under 1500897 CF10A. Bond is set at no bond. Your next hearing is at 8/28 at 8:30 a.m. Have a good day, sir. Xavier Francisco Barreto. Mr. Barreto.
How you doing?
Okay.
Your Honor, Mr. Barreto indicated to me that he has private counsel, a Mr. Kevin McGill. I called Mr. McGill's office. They confirmed that they do represent him and that Mr. McGill would be on his way over here. He was in the courthouse, but he has not arrived as of yet.
Okay. Mr. Barreto, we're going to put your case on recall so that we can hopefully have your lawyer present before the session concludes, okay? So at the jail at North Broward, please keep Mr. Barreto close by. Nicholas Ottman.
He's here present, Judge?
Mr. Ottman, you have a violation of probation warrant for case number 1401138 CF10A. Bond on that is set at no bond. You have capiases for suspended license, DUI, property damage, 2 counts. Bond is set at $750, $1,000 and $1,000 respectively. Have a good day, sir. And this is on.
You forgot to sign the judge.
Oh. Mark Parker.
No problem, Your Honor. Yes, sir.
Your Honor,
Yes, ma'am.
with Mark Parker, he was remanded in custody yesterday by his judge on his capias. So if you want to leave the bond as is, it's up to you.
Okay. Mr. Parker, you were remanded on capiases for case number 1700740 by your division judge, stealing and stolen property, false verification. I do find probable cause. Bond is set at $3,500, counts 1, 2, 3, and 4, 1,000, count 5. Have a good day, sir. Marlon Johnson.
Mr. Johnson, you remain?
We have a family member here.
Okay, Mr. Johnson.
It's a VOP, right?
Okay, ma'am, your name is?
Shaquanda Johnson.
I love that.
Shaquanda Johnson.
Shaquanda Johnson?
Yes.
Mr. Johnson, Ms. Shaquanda Johnson's been here all morning concerning herself about your well-being. Ms. Johnson, from sitting in the courtroom, you understand this is a very limited proceeding. You understand that, ma'am?
Yes.
Okay. Mr. Johnson, you have 3 warrants for violation of probation under case number 16009026 CF10A, 15005515 CF10A, and 1601084 CF10A. Do find probable cause as to each. Bond is set as to no bond as to each. The next court appearance is September 8th at 8:45 a.m. You want to write that down, ma'am? Okay. Have a good day, sir. Okay. Edward Willis.
Mr. Willis, come on up, please.
Mr. Willis, you have a warrant for violation of a warrant for possession of a controlled substance without a prescription. I do find probable cause. State any priors?
Here's a pending case for possession of heroin.
A pending case for possession of heroin?
Yes, Your Honor.
Bond will be set at $1,000. Have a good day, sir. David Winnington.
Is she coming back? I guess she's coming back.
Good morning, Mr. Winnington. You have a new substantive case for grand theft at Walmart. I do find probable cause. Mr. Winnington, have any priors?
I'm not showing, I don't know if pretrial has anything. I'm not showing anything out of Broward. Does he? Okay.
Felony petty theft, 2013, carrying a concealed firearm.
Thank you, pretrial. Bond will be set at $1,000.
Judge, Mr. Whittington has been living in South Florida since 1980. He is disabled. He receives SSI. He receives $775 a month. His rent is $725 a month, so he doesn't have a great deal of money for bond. He's active in his church. In fact, he plays drums in his church. He's been living in the same residence with his cat for the last 2 years, And if we can go sidebar for a second, I have some other information on Mr. Whittington.
State any objection to going sidebar?
No, Your Honor. Yeah, yeah, we're.
Trial release will be, the bond will be lowered to $500. In case pretrial is not able to verify information, I'm gonna impose pretrial release upon application and verification of the information.
Yes, Your Honor, thank you.
David, is your address 1834 Johnson?
Yes, sir. It
Okay.
is Hollywood, Florida.
Okay, okay.
Thank you, Mr. Reedy. Mr. Whittington, it's going to be pretrial release if your information can be verified. Otherwise, the bond has been lowered to $500. Have a good day, sir.
Yes.
Jeej Hosh?
Mr. Hosh is here, present, main judge. Judge, Mr. Hosh is financially indigent. Unfortunately, he's homeless, no money in bank, no property. He's 53 years old. He's asking, Your Honor, if you would consider an ROR.
I do find probable cause based upon the facts as alleged in the probable cause affidavit. ROR is declined, bond is set at $500. Have a good day, sir. Ramon Lanza.
Yeah, 580. Mr. Lanza, come on up.
Mr. Lanza, you have a violation of probation warrant under case number 140028863CF10A. Bond is set at no bond. Your next court appearance is on August 28th at 8:45 a.m. I wish you good luck, sir. Joshua Provost. Mr. Provost, you have a violation of probation warrant under case number 130036332CF10A. Bond is set at no bond. Your next court appearance is on August 29th at 8:30 a.m. Have a good day, sir. Russell Frazier.
North Broward, Mr. Frazier.
Your Honor, count 3 was corrected.
Thank you, ma'am. Where's Mr. Frazier? Do we have Mr. Russell Frazier available?
Says North Broward.
I believe he's at North Broward, Judge. I have him. You need it, Your Honor?
Yes, sir, please. Thank you.
Free. Yes, sir.
Good morning, Mr. Frazier. You have new substantive charges of burglary, conveyance, unoccupied, grand theft, burglary, conveyance, unoccupied grand theft, and a violation of probation under case number 04002652 CF10A.
Is that probation? Is that probation or RR?
Yes, sir, that's with Judge Ari Porth.
Right.
There are 11 allegations of violation on the violation. I do find probable cause for counts 1 through 4, and on the violation, state that you have a recommendation for a bond as to counts 1 and 3.
Your Honor, I do. I'm going to be requesting bonds in the amount of $10,000 per count, and should he post his bond, that he be supervised by pretrial release with a GPS monitor until more information can possibly be provided to the assigned judge. Your Honor, I have great concern for the property of the community. Mr. Frazier was arrested late June of this year and is out on bond for grand theft auto that has been filed. Additionally, the charges before Judge Porth on his probation are for burglary of a structure, grand theft. He also has a grand theft 2001, theft 2000, false imprisonment and battery 92. Nothing further.
Defense care to be heard?
Yes, Judge. Mr. Frazier's lived here all of his life, and he has family here, including his wife. He is disabled, so he's not currently working. He's been living in the same residence he lives in now for the last 23 years. He's the father of 3 children, all of whom are grown. He's provided me with the number of his wife, who he believes will be able to contact their bondsman to assist in the posting of a bond. But I don't believe that there's a tremendous amount of money here available, Judge. Based on the fact that he has a long-standing ties to the community with the same residence for 23 years, married father of 3, lifelong residents of this community, I would ask the court to consider a reasonable bond, maybe $1,000 on count 1 and count 3 for a total of $4,000. He's ROR'd on the violation of probation, so that shouldn't be a factor. I think that his wife, working with the bondsman, can probably come up with that kind of money.
Upon the argument of respective counsel, the facts of the case, and the applicable law, bond is set at $4,000 count 1, $1,000 count 2, $4,000 count 3, $1,000 count 4, and ROR as to count 5.
Thank you, Judge.
Next hearing is on August 30th at 8:30 a.m. Have a good day, sir.
Judge, if you want to recall Mr. Barretto, who's also up at the North Broward.
Xavier Barretto?
Your Honor, I just got off the phone with Mr. Barretto's attorney, Kevin McGill. Mr. McGill indicated to me that he cannot be here this morning. Mr. McGill is also aware that Mr. Barretto currently has a no bond hold for violation of probation. He's asking the court to set a reasonable bond on count 1, and they'll deal with everything, including the violation of probation, when the time arises. As he's aware, there is a court date of August 28th at 8:30.
Thank you, Ms. Horowitz.
And when the court is ready, if I may have an opportunity.
Yes, sir.
Thank you.
When you get back to your housing unit,
Where is that?
Parker.
Somebody's microphone is on.
It's north.
All right, go back to sleep again. 10 minutes, you'll be back.
Yes, State.
Thank you, Your Honor. Your Honor, upon review of the probable cause affidavit, I actually believe Mr. Barreto is undercharged. I think law enforcement would have been legally justified to charge him not only with armed burglary, but also with a more serious charge of fleeing and eluding, considering the rate of speed he was allegedly driving, eluding law enforcement. I'm very concerned for the safety of the community, considering he's on probation for a firearm offense, and the allegation is in the middle of the night to elude arrest. He unlawfully went into someone's property where there's allegations the gun was found on the property with a ammunition as well, Your Honor. I'm going to be requesting on count 1 a $25,000 bond, and on count 4 I'm going to ask for a bond increase to $10,000 with an order of no victim contact.
Mr. Reedy, do you have a phone number for Mr. McGill?
I do, Your Honor. He can be reached on his cell. I'd like to go go sidebar to give that number to the court. I also have his office number if you want that.
Well, it might be our phone just not dialing the exchange. (761) or 716? 716. Okay. Kevin McGill, please. Judge DeLuca from the First Appearance Courtroom in Broward County.
Hi, how are you?
Good. We are on the record, Mr. McGill. I tried calling you from the courtroom speakerphone, but apparently the maybe the exchange isn't helping us out. Are you at your office, or are you just available on the mobile?
I'm sorry, it's cutting out very badly.
Yeah, I know. Nobody else has cell phone. This is one of the few times maybe Sprint. This is the tower Sprint invested their money in. The one tower. Okay. Are you at your office where we can call you on a landline?
I am actually in the felony wing of the courthouse.
Are you able to come to the First Appearance Courtroom, sir?
Yeah, I can. Mr. Reedy has called me.
Well, the state's.
I hadn't actually been receiving this.
Well, if you. Let's put Mr. Barreto's case on recall. Whenever you get here, we have other cases, so don't so you have some time, and when you get here, we can then decide what makes sense.
Okay, beautiful.
Thank you, sir. Bye.
And what room of the new courthouse are you in?
What room is this? 4155. 4155.
Okay, thank you so much. I'll see you shortly.
Take your time, sir. Bye. Okay, Mr. Barreto, we're going to get Mr. McGill here. As soon as he gets here, we'll get you taken care of, okay? Thank you, sir. Mr. Reedy, thank you for your assistance. Tyrone Peterson? Mr. Peterson, Mr. Peterson, you have a new charge of possession of cocaine, possession of paraphernalia. I do find probable cause. Was Mr. Peterson interviewed for pretrial?
I'm showing that he has pending possession of cocaine, Your Honor.
A pending possession of cocaine,
yes.
Therefore the court would be disinclined to consider pretrial. Bond is set at $1,000. Have a good day, sir. Matthew Gauzy, you're giving this to...
He's got to sign. Oh.
Thank you, sir. Kevin Brown?
We have a chance. I believe we skipped over one gentleman, Matthew Goosey. He was on page 20. He was the gentleman before Joshua Provokes.
Matthew.
Right after Ramon Lanza.
Matthew Goosey?
Yes, Judge. Come on up, Mr. Goosey. Goosey or Goosey? Goosey. Okay.
Mr. Goosey, you have 3 warrants for violation of probation under case number 16004382. Bond is set at no bond. Your next hearing is on August 29th at 8:30 a.m. Have a good day, sir. Kevin Brown.
Good luck.
I have a probable cause argument as to the trafficking element of count 1.
Give me 1 second, Mr. Reedy.
Sure, of course. And the possession with intent on count 2.
State, you ready on this?
Yes, Your Honor.
Okay. Yes, Mr. Reedy.
I see probable cause for a possession of the cocaine, and I see probable cause for the possession of the marijuana, but I don't see a trafficking charge. The officer writes that the residence, additionally, around the residence were large amounts of clear, empty plastic bags and empty capsules.
What about the 31 grams? Doesn't that qualify for trafficking?
It depends on how much cocaine you like to do, Judge. I mean, that could easily be personal use over any particular period of time. I don't
Simple
think
possession
the
of an
amount.
amount over 28 grams is trafficking.
Go ahead, Mr. Reedy.
Sorry.
Oh, yeah, no, you're right. You're right. You're correct. You're correct. You're correct. Now, I don't see the delivery of the possession with intent to deliver heroin. Yeah, the trafficking amount over 28 grams would be a felony by itself. It would be trafficking.
And I have no argument as far as the heroin. I'm fine with probable cause for simple possession of the heroin.
Court finds probable cause for the trafficking as possession of over 28 grams. Court finds probable cause for the lesser included offense of possession of heroin. And count 3, there's a probation violation as to count 4. Let me just make notes here. Bond is set in count 1 at $15,000. On count 2, the bond will be set at $1,000 as opposed to the scheduled bond of $2,500. Count 3, $100, and no bond on the violation of probation and community control. The next hearing on the violation will be on August 28th at 8:45 a.m. Have a good day, sir. Thank you for your argument, Mr. Reedy and Mr. Linder.
And when I said it depends on how much cocaine you like to do, I wasn't specifically referring to you, Judge, so just so the record's clear on that.
Thank you, sir. Thank you for clarifying that. I got okay. Anton Watley.
Mr. Watley? How you doing? How you doing, sir?
Okay, Mr. Watley, you have 2 warrants for violation of probation under case number 1601136. CF10A and 160036364 CF10A. Bond is set at no bond on each count. Your next hearing is on August 28, 2017 at 9 a.m. Have a good day, sir.
In 4 days, you'll see your judge. Good luck, sir.
Michael Hillman.
Mr. Hillman? Good morning, Your Honor.
Mr. Hillman, you have a warrant.
Mr. Hillman declined the services of public defender, Judge.
Yes, I'd like to hire a private attorney, and I signed up for the pretrial release last night.
Yeah, you did speak with us.
And it would be my best.
His friend informed us that he resides in Marathon and that she has contacted a bond agent And he knows how much money she has, is what the friend told me when I spoke to her. I don't know what that means, Your Honor.
Mr. Hillman, pretrial contacted your friend, and they were in the process of contacting a bondsman. I am going to decline pretrial release. Bond is set at $33,500. Have a good day, sir. Hey, Billy McGill.
North Broward.
He's approaching, Your Honor.
Right, brought to you.
Mr. McGill, you're charged with grand theft. I do find probable cause. Was Mr. McGill interviewed for pretrial?
Yes, Your Honor. He was recently released from Florida State Prison in February of this year, and he does now have a pending felony petty theft.
Thank you, pretrial. Based upon the pending felony, pretrial is declined, $1,000 set as the bond. Have a good day, sir. Jesse Stafford.
Call your sister for you. Mr. Stafford, come on up, please.
Billy, I'm going to call your sister, so hang in there, okay?
All right.
Okay?
Yeah.
Mr. Stafford sent me.
Good morning, Mr. Stafford. You're charged with burglary and occupied conveyance and resisting an officer without violence. I do find probable cause. State have a recommendation for a bond?
Your Honor, state would be requesting a bond, $2,500 on count 1. No victim contact.
Judge, Mr. Stafford, he's 18 years old. He's been residing here his whole life. He's going to Sunrise High School. He's a senior. He lives with his mother in Fort Lauderdale. Been residing at the same location for about over a year now. Judge, and speaking Mr. Stafford, he's asking if Your Honor would consider an ROR in this case.
State any priors?
No, Judge.
And Mr. Stafford is going to school, is that what you said, counsel?
He advised me he's going to Sunrise High School, which is on Sunrise Boulevard, from what he told me.
Mr. Stafford, what grade are you in?
In the 12th grade, I'm going to finish off my credits. I have 3 credits left in high school.
Okay, and what do you do when you're not in school? That's productive.
When I'm not in school,
Yeah, what do you do that's productive?
productive, I usually fix on motorcycles.
Do you have any training in that?
No, but I want to go to Orlando for it.
Okay. So what are you planning on doing after high school?
After high school, either going to college for that or trying to find a nice paying job.
I don't know whether these allegations are accurate or not accurate. And so everybody's entitled to presumption of innocence. If there's any merit to this, you don't have any priors, get this put behind you. You're well-spoken, you're a reasonably big guy, if not a big guy, and you have a lot of opportunities ahead of you. You probably have a lot of challenges as well, but get this put behind you, get school finished up. I am going to release you ROR, sir.
Thank you, Your Honor. Thank you, Judge.
Andre Walker?
Mr. Walker, come on up, please.
Upon review of the probable cause affidavit, I do find probable cause. State any priors?
Your Honor, I'm showing he's got a $2,500 bond out of Dade County, a warrant for failure to appear. It's Dade County pickup only. Other than that,
Defense care to be heard?
I'm not showing anything.
State have a recommendation for a bond?
Your Honor, I'd be requesting because he has a pending warrant, the $2,500 bond I also requested on his co-defendant.
Bond will be set at $1,000 on this case. Defense care to be heard any further?
Not at this time, Judge.
Thank you, sir. Richard Ogle? Mr. Ogle, you have a new substantive offense for possession of cannabis and municipal ordinance violation and 2 warrants for violation of probation under case number 1600873 CF10A and under 1601154 CF10A. I do find probable cause as to each. Bond is set at $1,000, count 1, no bonds, counts 3 and 4. Your next hearing on the violation of probation is August 28th at 9 a.m. Have a good day, sir. Wesley Brooks.
Good luck, sir. Mr. Brooks, come on up, please.
Mr. Brooks, you have a new substantive charge for possession of cocaine. I do find probable cause. You also have a warrant for a misdemeanor, municipal ordinance violation. I do find probable cause. Bond is set at $1,000, count 1, $500, count 2. Have a good day, sir. Kenneth King.
Mr. King?
Good morning, Judge.
Judge, Mr. King is asking, he believes his sister may have already posted his bond. I don't know if confinement says, give us up-to-date information of that.
Jill, can we check on that?
While they're checking, Mr. King does have a pending felony 178154. He's out on bond on that case.
I don't see a bond posted.
The bond has not been posted yet. I do find probable cause for each count. Bond is set at $1,000 on each count. Have a good day, Mr. King. Anton Fleming.
Mr. Fleming? Yes.
Mr. Fleming, you have new substantive charges for grand theft, counts 1 and 2, uttering counts 3 and 4, and you have warrants for aggravated fleeing, resisting an officer leaving the scene, grand theft, fraudulent use of the ID of another person, and grand theft. Under case numbers 1601532 CF10, 1600933 CF10, 160079656 CF10 and 160079666 CF10. I do find probable cause as to each count. Bond is set at $1,000, counts 1, 2, 3, and 4. State, you have a recommendation for the aggravated fleeing?
Your Honor, actually, do you have the paperwork, or Judge? I provided yes. Because I think the specific facts are a bit aggravating also.
Do you have a recommendation?
Yes, Your Honor. I'm going to be requesting a $10,000 bond on count 5. First off, noting the specific allegations, while he was fleeing, he eventually, and thankfully there was minimal damage, but he crashed into someone's home. Additionally, his criminal history, and I will note, Your Honor, and I don't know exactly what is going on or what went on with the booking process, but I can tell you, and you can note on his booking sheet, every prior Mr. Fleming has is under the name John Mahorn. 2013 DUI, he violated probation. 2013 grand theft, criminal use of personal identification information with a violation of probation, 364 days county jail. 2013 grand theft, credit card fraud, criminal use of personal identification information with a VOP, 364 days. 07, burglary of a dwelling, grand theft, uttering a forged instrument, grand theft auto, again, criminal use of personal identification information, 4 years, Florida State Prison. 07, grand theft, 33 months, state prison. And lastly, 05, uttering a forged instrument, criminal use of personal identification information, and theft.
Defense care to be heard?
Judge, I do understand the state's concerns. However, in speaking with Mr. Fleming, he's 32 years old. He works in waste management, doing that for the past 3 years. He's making approximately $12 an hour. He lives with his parents. He lives in Margate, been residing with them for the past 3 years. He is a single father. His 4-year-old child does live with him. Financially, at this time, his father is going to be the only person that's going to be able to afford to help him with his bond, but he also works in waste management. Judge, besides that, Mr. Fleming is going to school. He's trying to change his life around. He's going to Florida Career College, studying at this time criminal justice. Judge, what I'd be asking you to consider is on count 5, setting a bond at $3,700, combined bond 1 through 10, that would make it a total bond of $10,000 on Mr. Fleming's behalf.
Thank you, Mr. Romero. Upon the argument of respective counsel, the facts of the case and the applicable law bond will be set at $10,000 as to count 5, 100 count 6 and 7, 1,000 as to count 8, 9, and 10. Have a good day, sir. Robert James. Mr. James, you have a new substantive case, possession of cannabis. I do find probable cause. You also have a violation of probation or community control under case number 16006957 CF10A. Bond is set at $100, count 1. No bond, count 2. Your final hearing on your next hearing on the violation of probation is 8/28 at 8:30 a.m. Have a good day, sir.
In 4 days this year, Judge. Good luck.
Sylvester Torzalski. Mr. Torzalski, you have a possession of a controlled substance without a prescription. I do find probable cause. Was Mr. Torzalski reviewed for pretrial?
He was, Your Honor, but we were unable to make a verification. If the court is inclined to do pending verification, we could do that.
Pretrial was unable to verify your information to Mr. Torzalski. I'm going to set the bond at $1,000 pretrial upon verification.
Okay, thank you, Judge. Let me explain to you what happened. It's $1,000. They're going to verify where you live. If they verify, then you'll be released on pretrial. Okay, good luck, sir.
Jermaine Parrish.
Mr. Parrish?
Mr. Parrish, you have a violation of probation warrant under case number 1604015 CF10A. Bond is set at no bond. Your next hearing is on August 28th at 8:30 a.m. Have a good day, sir. Jahan Jones.
Just make a note.
Mr. Jones, you have a violation of probation on case number 1500137 CF10A. Bond is set at no bond. Your next hearing is on August 29th at 8:30 a.m. Have a good day, sir. Gladstone Fuller. Gladstone Fuller?
He's with that North Broward. He's been Baker Act. I've been informed he was Baker Act.
Your Honor, I would just ask then if the court can make at least a probable cause determination, if it hasn't been done already.
The court finds probable cause. Bond is set at $500, count 1, and transfer the matter to the division. Thank you, Deputy, for the update.
No problem.
Corey Brown.
North Broward, Your Honor.
Mr. Brown, you have a warrant for grand theft. I do find probable cause. Bond is set at $1,000. Have a good day, sir.
Excuse me, sir. May I ask you a question, sir? I don't even know what I'm in jail for, sir. I mean, what is, like, I don't even know what it is that I stole, sir.
You have a case pending in front of Judge Michael Usan. And the allegations of the probable cause affidavit are on June 7, 2017. That there was a shoplifting that occurred at Let's Go Wireless, Nova Drive in Davie, Florida. Have a good day, sir.
All right, thank you much, sir. Hey, sir, can I ask one more question, sir?
Of course.
I'm sorry, sir. Can I get like a ROR pre-trial release, sir? Because like I'm like right now I've been missing work ever since like Monday, and like I just wanted to get out of here, sir. Right? You help me out, please, with a pre-trial release or something, Your Honor, please, sir.
Sir, I'm going to decline that opportunity at this time. The bond will remain $1,000. Have a good day.
All right, thank you much, sir.
Joseph Felser. We have Mr. Felser somewhere.
Your Honor?
Oh, is that the video?
We reset him from yesterday.
Yes, sir.
Your Honor, he went before his division judge yesterday, and he was released on pretrial GPS.
He went to his division and he was released?
Yes.
Okay, thank you.
That was the reason the court had reset him.
I appreciate that. Xavier Barreto?
Your Honor, these are pending verification.
Kevin McGill on behalf of Mr. Barreto.
Let's get Mr. Barreto here.
You approach it.
Mr. Barreto.
How you doing?
Okay, Mr. McGill is here.
Morning, Xavier.
He dropped everything.
McGill?
He dropped everything to come over here to
I
represent
really
you.
appreciate that, McGill. I'm sorry for bringing you here again.
Hey, now Now, Mr. McGill, you indicated that you have not resolved your engagement yet, is that correct?
Yes, Judge. I had gone to the jail to visit Mr. Barreto yesterday. However, because of the injuries he sustained at some point, either before or during the arrest, took him several hours to get through intake, so I wasn't able to meet with him. My intentions are to handle his case. However, because he is on probation in front of the Honorable Dennis Bailey, felony probation, my concern is that he's going to be held without bond regardless of what Your Honor chooses to set as bond on the new charges. I am prepared to make an argument regarding the bonds in the new cases.
So are you prepared to go forward representing Mr. Barreto for the limited purpose of first appearance at this time?
Yes, Your Honor.
State, do you care to be heard on the bond to be set on? First, let me back up. Mr. McGill, have you had the opportunity to read the probable cause affidavit?
Yes, Judge.
Okay, so you're comfortable going forward at this point?
Yes, Your Honor.
Okay, thank you,
Mr.
Your Honor.
Linder, recommendation as to bond on count one?
With regards to count one, Your Honor, I'm going to be requesting a $25,000 bond. With regards to count four, I'm going to be asking that the bond be increased to $10,000. The basis for my argument, one, Your Honor, as I stated earlier, I believe law enforcement would have been within, it would have been reasonable for them to charge Mr. Barreto with armed burglary. It appears based on the allegations that he unlawfully entered the victim's property while armed with a firearm, noting also that he's on probation right now for a firearm offense. Also noting his criminal history includes 2011 unlawful use of false name ID, resisting without violence. 2011 battery on a law enforcement officer, resisting without violence. Also noting, Your Honor, just the rate of speed he was traveling at, mentioning while police were following, trying to get him to stop with their lights and activating siren, he runs a solid red light. He is clocked at driving 117 miles per hour, Your Honor. I believe Mr. Barreto poses a significant danger to the community.
Mr. McGill?
Your Honor, I'd only proffer to the court that he lives in Broward County. His entire family's in Broward County. His job and career are in Broward County. He has no intentions of leaving. He's never missed a court date or had capias issued in any of the cases that he has been arrested for. I'd also just like to remind the court that he's going to be held without bond on the violations probation. I'd hope that Your Honor would just consider that and we'd ask that maybe you consider a $10,000 or a $15,000 bond as to count one, which is the burglary of an unoccupied dwelling, and leave the other bonds the same.
Upon the argument of respective counsel, the facts of the case and the applicable law, at magistrates, I'm required to set a bond as to count one. As to count one, I'm going to set the bond at $25,000. I am going to leave the remaining bonds in place. Certainly, I'm not disagreeing that with the state that the ultimate filing as to count four may be maybe more serious than it's alleged, but I'm going to leave that in place as it is. 1,000 count two, 500 count three, 2,500 count four, $750 count five, and no bond on the violation of probation, which is under case number 16007051051CF10A.
And Your Honor, I would just ask for, in an abundance of caution, order of no victim contact with the alleged victim of the burglary.
And no contact with victims or witnesses in the matters directly or indirectly pending further order of the court of competent jurisdiction. Mr. McGill, I'm showing the next hearing on the violation of probation on 8/28 at 8:30 a.m.
I'm sorry, on 8/20?
8/28, so that's
8/28.
Monday at 8:30 a.m.
That sounds correct, Judge.
Okay. Anything else, Mr. McGill?
No, thank you, Your Honor.
Thank you for coming over, sir. Any questions of me, Mr. Barreto? It's probably in your best interest not to say anything at this time.
All right, that's it.
Anything else by the state?
I'll be out there to see you.
Your Honor, if we could just check, if maybe, did we put Mr. Hyacinth on recall, or?
Thank you very much, Your Honor.
Yes.
In fact, I just heard from the jail on Mr. Hyacinth. They have him up in North Broward. He is declining to join us. And I am looking for him on the docket. He is on page 13. It's a trespass. Deputy, does he understand he might be able to resolve this case? Or what's...
I wasn't gonna be making an offer, but.
Huh?
I mean, just for the record, based on the allegations, I wasn't gonna be making an offer, but I don't know if the judge was inclined to.
Why don't we just reset it till tomorrow?
Okay.
If he's not, doesn't wanna come and visit and
All right, we'll reset it
chat
till
with us
tomorrow.
today, reset till tomorrow. Thank you, Deputy. North
Maybe he'll
Broward.
be in a better mood tomorrow, Deputy.
Hopefully.
Or if he changes his mind, you can bring him on at the 1:30 docket as well.
All right, I'll try.
Thank you, sir. Anything else by the state for the morning?
Yeah.
We're all set, Judge.
Nothing from the state.
Nothing from defense.
Clerk?
Nice lunch.
Pretrial, jail? Okay, we are in recess until, was it 1:30? 1:30 or 1 o'clock?
Do 1 o'clock if you want, I don't.
Okay, so 1:30. Okay, we'll see you at 1:30.
No, I'm fine with 1 o'clock. Oh.